Thanks a lot for coming to attend our roundtable, which is called The Principles of International Law in the 21st Century. Is it the time to take stock of them? I think this is a wonderful gathering of renowned international law experts. Konstantin Konstantinovich, speak of the angel. Now we're all set. So the international law is becoming more and more topical as opposed to the recent developments. And I'm talking about the sanctions, which for the last several months been a buzzword on the TV. But we'll be talking more than just about sanctions. The Russian Federation has joined and ascended to WTO. The common economic space is being created, and it's now functioning. So the number of international institutes somehow related to the international law and that Russian Federation is taking part in is getting more and more numerous. I'd like to now introduce to you our panelists. First, Tatiana Neshatayeva, who is a professor, who is also the vice president of the Court of Eurazes. Then Bakhtiyar Tuzmukhamedov, a judge from the Appeals Chamber of the International Criminal Tribunals for Rwanda and the former Yugoslavia. He is the Doctor of Legal Sciences and a professor as well. Third, Nikola Silakovic, Minister of Justice, the Republic of Serbia. Georgy Matyushkin, representative of the Russian Federation at the European Court of Human Rights, Deputy Minister of Justice of the Russian Federation, candidate of Legal Sciences. Konstantin Dolgov, Ambassador at Large, Commissioner for Human Rights, Democracy and the Rule of Law, the Minister of Foreign Affairs of the Russian Federation. And last but not least, Sergei Usoskin, Head of Research Programs in the Center for International and Comparative Law. And my name is Khristofor Ivanyan, representing the Ivanyan and Partners law firm. Now I'd like to give the floor to Tatiana Neshatayeva and ask her to share her ideas and views on what's happening with the international law now and what are we to expect in the nearest future. The organizer told me from the outset that we need a scandal in here to set off the scene, to set the ball rolling, so that's why you probably gave this floor to me. But I do hope that we will be able to avoid the scandal, and we will get a very good and a very active and vivid discussion, because I'm not going to discuss some theory with you. I'd like to tell you about the things that I have been experienced for at least 20 years. When I was just a teacher, when I was not even a professor, I can tell you that this topic of super imperative norms and principles was not bothering me back at the time. But as soon as I landed in a court, as soon as I saw our court system from within, and I can tell to you for sure that any professor like me would experience a shock. And this shock I still experience up till now. And I think that the main thing that can really save you, that can really help you to keep going, is an old, ancient Institute of International Law and its principles, the backbone of this institute. And only after that, since I had to deal with it on practice, I decided to investigate this topic in much more details, and I decided to do it conscientiously. So now I would like to introduce to you my own vision of the topic at hand, and I'm pretty sure it will not correspond to the major ideas expressed in books, but this is an idea that is very well in line with the principles of the Russian Federation and the Eurazes Union. I think the common source of the principles of law is the natural law. Call it as you wish. You can call it the moral law, ethics, or whatever. For me, I'd like to use the term natural law and natural laws in a way that was formulated by Foma Diakotanis. And theologists were the ones who started developing this principle at the outset. And basically and mainly it was done by Christian theologians, both Protestant and Catholic. Both Catholic and Orthodox. But Orthodox theologians are not viewed as positively as Catholic. And Foma used to say that there are three main principles for any human, and I think these three principles still remain. It's the right for life, the right for freedom, and the right for happiness. Casseza has translated the right for happiness into a more modern form. It's the right for effective behavior, so that the person can feel okay and right. And then started the whole path of development of those principles. You know that Catholics wrote about that much earlier than that. But there was one more right that was only introduced by the Orthodox theologians, for example, the right for bread, or which later translated into the right for property. Catholics only reviewed this right as the right for life. Then it continued, the ball continued rolling, and then it got fixed in norms and regulations. But unfortunately, this fixation, or it hasn't been actually divided into general principles of law and generally recognized principles. However, I believe their nature is singular. It's the same. All these principles are natural laws, but they were fixed in a different legal form. However, this existing wording in the Constitution, the generally recognized principles and norms, to me includes and incorporates everything, because if you read the Charter, the UN Charter, general principles and norms, it really talks about those principles in their old form, so to say. In the form that theologians used to describe it. Non-violation of law and decency and so on and so forth. These are the kind of terms that would be used by them. Generally recognized principles and norms, this formulation to me includes everything. I believe that the current all-union agreement that was signed on the 29th of May incorporates the same formulation. And quite unexpectedly for me, all the sources of international law have been included into this new charter, and all internationally and commonly recognized principles and norms were also incorporated into it. But what's a challenge that we have to face? What is the problem? Very often we would include into some international document something that is not considered to be a commonly recognized principle. Some of the norms that were fixed in the Charter, in the UN Charter, there are only 7 principles that found its way to the UN Charter. Although we try to expand this list up to 10, and that's what we try to do in all the books, that's what we describe in the literature, that actually led us to a deadlock with the Crimea here, because what we have is just those 7 principles, and they are super imperative in terms of their character. Now, as for the general law principles, they're definitely in line with them. Parta supervanta, for example, is included in both cases. But these general principles are mainly fixed in court decisions and rulings. Yes, they definitely were developed, and they found their way into laws, they found their way into court proceedings, for example, bona fide, non-violation of law, and so on and so forth. They all found their way to various procedural principles, and in those cases where they were not developing this way, they appeared in various law books, but at least they are treated as super imperative norms that are recognized by everybody. Now, why I believe for courts this form is the most crucial one. Our national leader constantly remembers such court decisions due to certain reasons, because we can only find confirmation of their existence in such decisions, that only practice can confirm their existence, because only if it came through the court practice, only if it got the usage opinion unis, you can tell that the principle is realized. Well, if the principle finds its way to the UN Charter or the Union Agreement that we signed on the 29th of May, then, of course, it is seriously fixed. It exists in the written form, and the written form is always much more effective than the non-written form. But for court practice, to be precise, a non-written form is more effective. Why? Because this backbone of international law, this natural law, is very well in line, is very well connected to the human nature, is connected to the life on the earth, to the reason why it exists, and it is connected for eternity. And it can be referred to in not ordinary situations, in complex situations, for the judge to make a right decision, because written norms and written acts and written regulations cannot extend and cannot cover all the situations in the world. Moreover than that, our life is so diverse, has so many facets, and the court practice shows that, even at an international level and the level of the High Court, however strong your desire is to find a particular written norm, a particular law, there will still be a situation when that or a written norm will not be enough. So the only thing for the judge to do here would be the only way out of the situation for the judge is to find out what kind of principles can be applied to the situation, what is applicable, how can you regulate the situation, how can you close it down, based on that backbone of the international law. However, there's always a danger. You can always be called an innovator, you can always be called too optimistic, you can always, create some new things, and a decent judge, a judge with good education, must really restrain himself from going into this domain. However, I did see a number of judges who really want to become creators of new principles, but very often it leads to a deadlock, or it leads to a very bad end. So, in case there is a complicated case, what kind of way out for a judge we can see? Only using court decisions of international courts, using the decisions or rulings of those who did it before you, only using the decisions of those who is working in parallel to you. Luckily for us, there's a whole range of such supranational courts. For example, 2 European courts, one in Luxembourg, the other one in Strasbourg, the Hague Tribunal and the Hague Court. And when you look at these rulings and these court decisions, you can see that outside these 7 principles, and as far as the Serbian decision is concerned, actually, it is very well in line in those 7 principles. It doesn't create any new principles. And the same happens in trade relations. The same happens in WTO rights and law, in the Eurozone Union law. We have a number of a number of cases. Very often somebody would say that they would go to WTO and overrule our decisions. However, the decision is much more difficult to obtain at that level, but still. And in this situation, you can only have that kind of a way out. You need to really have a look at what principles, what old principles of international law support your practice, or support this particular practice, and try not to exceeded. In Eurozone court, pacta succipanta has been actually used. There were 2 cases, and there was a threat that they would go to WTO and argue about our rulings. The bona fide principle, and so on and so forth. And here I'd like to talk off topic a little bit. Right now, I was just talking about those old, commonly recognized principles, the ones that we derived from religious postulates, the principles that came to us through and from and via science, and via many different contracts. So these principles are based on a long history of international law practice and international disputes. But we know for sure that if we take the European Court that deals with three main freedoms, the right for life, the right for freedom, and then the right for happiness, this court has developed many offsprings, for example, of those main principles. For example, the right for identity. This is a kind of a principle that we were using quite a lot in our Supreme Court, in the Eurozes Court. Procedural effectiveness, for example. Well, these new principles, they can either be called completely new, or we can actually call them the old ones, but using the new formulas or the new wordings. I believe that these are the same old principles of a non-violation of law, because they are tied into all modern court principles, but they haven't yet been divided and they haven't been yet separated to a super imperative form, like the principles introduced to the UN Charter. So to my mind, it seems that the future of those internationally recognized principles of international law is connected and tied into the court practice and court proceedings, because those things that will pass through courts, those things that will be fixed in court decisions, those things that will be fixed in the discussions of international law. And you know that there's a lot of international laws. Everybody's talking about fragmentation at the moment. Actually, I do not agree with this principle, because there's no fragmentation. Yes, if we do try to have a look at this, we will mainly see that the decisions that international laws are making are tied into each other, are juxtaposed against each other. So there's no major difference. But what will find its way to a written form, like, for example, in the UN Charter, or like the agreement we have recently signed, the regional one, well, that is the question of sense, of rationalism. We really must use the Occam's razor. We don't need to take any excessive things on board and something that is not used. But whether it will be like this in the future, I don't know. We'll live and see. Now, based on this thesis, let me explain to you a bit the situation that exists currently, the situation that we're discussing today. I call on you to remember that when you're talking about this topic, amongst those super imperative principles, which are 7, self-identity, equality, and sovereignty are equal to each other, and there's no red line in between those principles. The main specifics, the main characteristic of these principles is that they are not hierarchical to each other, they are not replacing each other, and they're used depending on what kind of arguable and complex situation is reviewed by the court. And I think, and I'm gradually driving to that, those 3 principles, of which a lot has been said in various documents and literature, and which are prescribed and described in the Helsinki law, are not yet commonly and generally recognized, because there is no practice that will confirm their viability. Maybe in the current situation, such practice will appear, and then there will be a court ruling based on this principle. But I believe we were too short-sighted when we said that there are 10 principles of that kind and not 7.
Thanks a lot, Tatiana Nikolaevna. I'd like to give the floor to the Minister of Justice of the Republic of Serbia.
dear colleagues, dear participants in this, it's not so-called round table, there is no table between us, and the dear participants of the forum, first of all, I would like to thank to all the people who've organized such a glorious event, something which is completely rare in our profession, in Europe as well as all around the world. Thank you so much, Madam Professor and Judge, about your discussion, which has been really, really inspirative, and which put me back in my school benches on the Faculty of Law of Belgrade. I will try to give one perspective towards this issue from a place of a minister, so justice minister, as a politician, as a lawyer, as a kind of practitioner. Especially bearing in mind that my country used to be as well as testimony, as well as witness during the last few decades. I've been studying, and one of the first lessons on international law used to be a question of my old professor: is it really a law? Because the law needs a couple of really, really important characteristics. The first of all, if you are talking about civil law, it needs the equality between sides. And it is really hard to talk about the equality of all the participants of international community during all the history as well as today. The second of all, each law needs an effective sanction. And if there is no an effective sanction, there is a free space to pose a question: is it really a law? But fortunately or unfortunately, within 2 last decades, we are testimonies of the efforts of international community to make international law a law, through giving it some of these characteristics. On the first place, the sanction. So I would like now to concentrate on the speech I've written, and I will try to be completely concrete. Well, it is my great honor to take part of, on behalf of the Republic of Serbia, at this forum dedicated to fundamental matter of the international law, the matter of international law principles in the 21st century. The Republic of Serbia expresses its commitment to the purposes and principles of the UN Charter, the UN Millennium Declaration, and the World Summit outcome in 2005. Commitment to preservation of fundamental values, including freedom, equality, solidarity, tolerance, respect of human rights, respect for nature, and shared responsibility as essential basis for international relations. Contributes at the same time to achieving the further fostering of basic principles of international law, as it is established in the UN Charter and the Declaration of Principles of International Law concerning friendly relations and cooperation among states. International law principles, and especially the UN Charter principles, represent the imperative of modern international order. At the current level of development of international law, it is carved out a place of jus cogens, cogent norms. However, it was not uncommon that the United Nations Charter principles were interpreted in a legally unacceptable manner. In the practice of international relations, even the basic norm of the UN system as a peaceful order, the norm of prohibition of a threat of force and use of force, was frequently interpreted based on subjective political criteria especially through broad interpretation of the right to self-defense, exceptions from prohibition to interfere into internal affairs of other countries, and similar. The modern international law order is based on the UN Charter principles, which is a living instrument and should be further developed on civilization achievements embodied in a number of international instruments, especially in the Declaration of Principles of International Law concerning friendly relations and cooperation among states from 1970, the International Convent on Civil and Political Rights, and the International Convent on Economic, Social, and Cultural Rights. Unilateralism, that was regretfully dominant since the last decade of 20th century, is in a deep gap with the nature of international law. Further development of international order to make it efficient and harmonized with the set goals must take place through multilateral dialogue, through reaffirmation of mechanisms providing for in UN Charter, strengthening of the role of United Nations in further development of international law, and strengthening the multilateralism in dealing with global challenges. Therefore, the crucial importance for application of international law principles lies in implementation of conclusions from the World Summit Outcome 2005 that emphasizes the need for reaffirming the vital importance of the effective multilateral system in accordance with international law in order to better address the multifaceted and interconnected challenges and threats confronting our world, and to achieve progress in the areas of peace and security, development of human rights, as well as the central role of UN, and commit ourselves to promoting and strengthening the effectiveness of the organization through the implementation of its decisions and resolutions. The attitude toward application of international law and rules and standards on human rights should not be followed by political opportunism and balance of power at the expense of achievement of objectives defined in the UN Charter. Correct interpretation and application of international law are closely tied to activities of the United Nations as political organization that should be, by the definition, the center of coordination of collective efforts of the member states to achieve objectives of the UN Charter based on the relevant legal rules. Therefore, my attempt to transform this organization, any attempt to transform this organization into organization for assisting to the unilateralism, or as a coverage for acts resulting from unilateralism that are in direct collision with principles of international law and reasons for foundation of the organization, should be thwarted. The Republic of Serbia shall strive to contribute to foreseeing the international law principles, among the other, by presiding over the OSCE in 2015. During the marking of 40th anniversary, so 40 years since the signing of the Helsinki Final Act. It is a great responsibility for my country, having in mind the actual international tensions, for which we hope it will be settled in a peaceful way in accordance with international law. A typical example of subjective political interpretation of basic principles, unambiguously violating principles of the UN Charter, was, among the others, the aggression on the Federal Republic of Yugoslavia in 1999, that was made without the decision of the UN Security Council and without any ground in the norms of international law. The Federal Republic of Yugoslavia was ready to search for a peaceful solution of the crisis, and it had concluded the agreement on verification mission with OSCE that provided the assignment of 2,000 of foreign observers. The biggest crimes, especially in Kosovo and Metohija, happened during and after the NATO bombing. The UN system was comprised soon after the UN Resolution 1244 was adopted. It is the presence of United Nations mission in Kosovo and Metohija and international security forces in Kosovo and Metohija that was abused during the declaration of independence that was made outside the institutional frame established by Resolution 1244 and United Nations mission in Kosovo constitutional framework for provisional self-government in Kosovo. Reaffirmation of the role of United Nations also assumes fulfillment of obligations from the Charter and giving priority to obligations based on the UN Charter, including the compliance with the obligations from the UN Security Council Resolution 1244 that represents, as established also by the International Court of Justice, an integral part of international law. Within the context of discussion on principles of international law, the question arises related to forming of special legal regimes in respect of which the fear is expressed that it may lead to diversification and fragmentation of international law. However, although frequently defined as self-sufficient, those special legal regimes were not initially designed as systems contrary to general international law, and in any case, it must form a part of general international law and not its substitute. An example of the formed legal regimes that are not in accordance with general international law is the system of rules applied by the International Criminal Tribunal for Former Yugoslavia, ICTY. The law that is applied and its practice are significantly different from the solutions accepted by the International Criminal Court, established by the Rome Statute, and that are applied in the practice of the International Criminal Court. International Criminal Tribunal for Former Yugoslavia has abused the mandate guaranteed to it by the Security Council, hindered the process of reconciliation at the territory of former Yugoslavia, and compromised the idea of the international criminal judiciary. It is a paradox that we can speak today about many international criminal laws, as there are international criminal courts, and all of it have mandate to apply rules that without any doubt constitute a part of customary international law. Political instrumentalization of international criminal judiciary is followed by formation of legal institutes that are unacceptable to the permanent criminal court. For example, in the practice of ICTY, the so-called joint criminal enterprise is deeply rooted as the base of responsibility, and it has no foundation both in customary law or in the ICTY statute. The Permanent Criminal Court has explicitly rejected it. Some institutes, for example, formal receipt of notice of adjunctive facts or acceptance of evidence by testimony from other cases without possibility for examination of witnesses, etc., are not accepted by international institutions formed in the legally proper manner. if various international criminal courts and tribunals referring to general international law and principle of individual criminal liability in substantially different way are solving matters of forms of responsibility and other fundamental issues of international criminal law, one cannot make another conclusion but that even in this very important matter, almost nothing remained from the rule of law and legal certainty. I will be a little bit shorter and I'm going to miss the rest of this page, so I'm going just for the interpreters to get the other page. The rules of international law should be supplemented with clear rules for work of United Nations peacekeeping missions and other organizations. Multinational operations, as we learned from practice, in order to be more efficient, should be based on clear mandate with resistance to conduct missions in the manner in which unilateral military, economic, political, or other interests of some of participating countries are achieved. One of the challenges of the actual international politics is the fight against terrorism. My country supports the efforts for the adoption of comprehensive convention against terrorism that would not recognize exceptions of so-called special cases where terrorists and terror acts would be approved or covered by a lagged fight for freedom. Legal regulative on the fight against terrorism must not only be in accordance with principles of international law, but it should also supplement international law with new principles that will discourage any act leading to terrorist actions. And finally, the Republic of Serbia is deeply committed to achievement of objectives set by the United Nations Millennium Declaration. Fundamental values that are crucial for international relations in 21st century include freedom, equality, etc. in meaning upon the world economic and social development and threats to international peace and security. The UN, within the frame of existing mechanisms, should have the central role in promoting and rationalizing. In order to achieve it, it is necessary to strengthen respect for the rule of law in international as in national affairs, and in particular to ensure compliance by member states with the decisions of the International Court of Justice, in compliance with the Charter of United Nations in cases to which they are parties, as well as strengthening of the overall role of the United Nations, especially in area of preservation of peace and security and commitment to peaceful solution of international disputes. I'm sorry for taking so much time of you, but
Minister, thank you very much.
That I've been more than concrete.
Thank you very much for your thoughtful presentation. I hope
I would like to pass the floor to Bakhtiar Tuzmuhamedov, who planned to talk about the limits of application of the principle of non-use of force. I would remind you that he is the Judge Appeals Chamber of the International Criminal Tribunals for Rwanda and the former Yugoslavia. He's a professor of law, and the previous speaker spoke a lot about the fate of the former Yugoslavia, and probably Mr. Tuzmuhamedov will not bypass this issue. I won't. Well, first of all, I would like to extend my gratitude to the organizers for inviting me to participate in this forum. My special thanks to the legal firm Ivanyan and Partners for inviting me and allowing me to speak at this round table. But it's more than politeness. You understand that you will be responsible for everything I say here. As for the speech of Minister Selakovic, you see, I'm here as a private person. And because I'm a private person, don't expect me that I will criticize the International Tribunal on former Yugoslavia. And because I'm a judge, don't expect me to protect it or excuse it. Despite the acute criticism of that tribunal, I think Serbia and the minister are maintaining a dialogue with that tribunal. They recognize it. As for my position concerning certain declarations by that tribunal, well, I have a special opinion on certain cases, including the cases related to the Kosovo events of 1999. I will not comment upon that, but I think that my position there is quite well expressed. Tatiana, thank you very much for blazing the trail for me. The principle that I wanted to talk about is a super imperative, a root principle. But when preparing my notes for this forum, I realized I had more questions than answers, questions to myself. I have answers to some of them, but Tatiana, you and I learned the law approximately at the same time. And you understand that the international law has the principle of non-application of force or threat of force. We were given a black and white picture, and the shades appeared somewhat later. When we familiarized ourselves with some doctrines different from domestic doctrines, in particular, after we got some practical experience, and the major questions that I asked myself is, to what extent the formal reading of the UN Charter and the literal understanding of the principle of non-application of force corresponds to reality? What is the practice of the UN and separate member states in what relates to non-application of force? If we look at the letter of the Charter, there is the following. I will just read out. All the member countries of the organizations will refrain from the use of force or its use against the sovereignty or political independence of any state, and from any other use of force incompatible with the purposes of the UN. Professor Maleev believes that the term refraining does not mean that it forbids the use of force, but the whole practice proves that this constitutes a prohibition to use force. But there is one permission. One permission is to use the force with UN sanctions in a collective action in order to maintain or establish international peace and security. The second situation is self-defense, individual or collective self-defense, in a case of an aggression. Article 51. I would like to emphasize that not every illegal use of force is, in fact, an armed aggression, which may be the reason for enjoying the right for self-defense. Well, how do we interpret those provisions of the UN Charter? First of all, there is a prohibition to use force, and we see a certain permission within certain limits. That is self-defense. The right of self-defense was there long before the UN Charter and continues to exist with or without the Charter. The prohibition in Article 4, the very principle of non-use of force, is not absolute. The force or the use of force are prohibited concerning territorial integrity, When Mr. Gromyko wrote to the organizers of the San Francisco conference that such a principle is proposed for Article 2 of the Charter, he wrote a territorial, quote, territorial integrity, unquote. It is only the Russian text that is different. The second component is political independence, and the third component are the purposes of the UN Charter. So there are certain situations where you can use armed forces without interfering with those basic purposes defined in the Charter. The practice of UN concerning Article 42 does not meet what's written in the Charter. There is no collective tool, the UN armed forces, although sometimes we call military peacekeeping forces UN armed forces. Unfortunately, the Charter provisions related to that have never been implemented. And in the absence of that collective tool, the UN had invented a palliative mean. The first one is the peacekeeping of operations, which is effected under the leadership of the Secretary General on the appointment of the UN Security Council, and where which actually wear two hats. On the one hand, they are subordinated to their own command. On the other hand, they are subordinate to the UN. But it went even further. Those peacekeeping forces, which usually separated the parties to the conflict, are now more and more used in internal conflicts. And more than that, from a purely buffer function, they were transferred to using force not just for self-defense, not just for defending the mandate, but using force in an offensive. More than that, those UN forces have been known to get a mandate to act on behalf of a certain government. Look at what's happening in Mali. So we are faced with not just non-application of Article 42 and other articles related to collective action, we face an erosion of the literal understanding of this article, the self-defense right. There's a lot of shades of gray here. In particular, there's a major issue, and not only the doctrine, but the practice collides with this. Do you really have to wait for an armed aggression? Do you have to wait for an aggression? Do you have to wait until huge damage is inflicted to the country and only then respond? Would you have the time to respond to such an aggression? Tatiana mentioned Guga Grotz, and he applied. René Davatel wrote about the same thing, about the preventive action. There's a typical example of 1937 when the British troops, of 1837, when the British troops entered Canada and burned down an American vessel, Caroline, which brought munitions to the fighters for Canada's freedom. And we may see that not only as a use of force in case of an aggression, but in the case of an extreme need. The Nuremberg Tribunal used that case against the Nazi criminals and against the because the Nazis occupied Norway to prevent the British from landing there, and that was the Nazi argument, and the tribunal did not accept that. The Tokyo tribunal interpreted this case in a different way concerning Holland, which declared war on Japan. And the UN uses all this case when it justifies the urgent need. The non-application of force is mainly seen from the point of view of international law, but there's also a question about sanctions. What sanctions? What are the sanctions about? What are the permissions? What is the document that permits the government to use force beyond the limits of their country? In Russia, this is the constitution. In the US, it's a law on authorization for the use of military force. And in Germany, it's a different law. It doesn't always work. It's not always that the executive powers ask the parliament to agree. This was the case when the US attacked Yugoslavia in 1999, and actually it happened in the same way with Libya, when the president did not get the agreement of the Congress. In Libya, the executive power did not ask the Bundestag to evacuate German citizens from Tripoli and other places. I don't know whether you all know about that, but currently there are 3 permissions in the Russian Federation to use force abroad. The first one is the result of capturing the personnel of the Russian embassy in Baghdad. That permission is still in force. The Council of Federation allowed to use force after the Georgian forces attacked the Russian soldiers in peacekeepers in South Ossetia, and the recent resolution about the possibility to use military force in Ukraine. Not everything is clear. Which of those levers have changed? Which of them have been eroded? And I can say about those acts that from a formal point of view, I would expect some system of accountability and those legal documents do not provide for accountability. They are not quite clearly written. So there's a lot of things to think about. I found a very good quotation which I would like to finish my speak with, and it belongs to a person that some of us may know personally. It's one of the it's Oster Schachter, one of the outstanding lawyers of modern times, claiming that every state can freely decide when and to which extent to use arms, devoid the possibility for international condemnation and actually allow the unilateral use of force. And thank you very much for the candidate. I'm not a doctor of law, candidate of law. Thank you, Bakhtiar. Thank you for a very good speech.
It is a pleasure to me to once again introduce to you Georgy Matyushkin, who is the Deputy Minister of Justice of the Russian Federation. Please, Georgy, the floor is yours. Thank you very much to you, Khristofor. Good afternoon, ladies and gentlemen, dear colleagues. Following a very wise example set up by Bakhtiar, I'd like to say that I'm in my personal capacity in here, and I will not going to speak as the Deputy Minister, and God forbid, I'm not going to speak as the representative of the Russian Federation at the European Court of Human Rights. Tatiana, you set up the tone, and you set the ball rolling, and I fully agree with many things that she talked about, apart from maybe one thought. In her presentation, she said that this sentence is not right, that there's some fragmentation trends being noticed in the international law. I have a very different opinion about this. I believe that in the recent times such fragmentation does take place. The international law is now divided into two fragments. One is the Court of Human Rights practice, and the rest is everything else. And the other fragment is everything else. So that's what I would like to talk about today. Today, we believe there's a necessity to raise a question again and again about the competence of the European Court of Human Rights in accordance with the Article 19 and the Article 1 of the Charter. For example, international responsibility of states as far as illegal actions of other states are concerned, and these questions have to be discussed at various international forums. We need to discuss such questions and how different liabilities and obligations are met, because these principles are tied in to the subsidiarity principle, which is the cornerstone of all the European system of protecting human rights. To our mind, the most crucial one is to identify the legal position of the European Court of Human Rights about the extraterritorial liability of the states, which will be covered by us in separate decrees and separate documents of the European Court of Human Rights. For example, the Catan case, the ESHR confirms there's no witnesses and there's no evidence of the participation of Russia as far as the closing of schools in Moldova is concerned. And it was stated explicitly that there are no evidence of Russia's participation, neither there is any approval of Russia as far as the policy of the states is concerned towards the language used in this republic. Also, the ESCHR noted that as soon as the schools were closed, Russia was acting as an intermediary to overcome the situation, and thanks to its participation in the mission, the schools were open again. So the court paradoxically ruled out that Russia was rendering an effective control over the events at hand. It was providing economic and political support to the government of the Transnistria, and during this period the Russian armed forces were stationed in the Transnistria. And also it is surprising that the next point states that Russia was proposing its economic support in order to help the most vulnerable population and victims. Such treatment of the effective control is coming into opposition with the norms of the international law, and it can help to enforce the government to comply with the law, because in such case the country that is rendering economic help to other citizens is violating the law. We need to remind you that Russia was participating in the Transnistria conflict only as an intermediary in a recognized capacity. Also, we have to say that the European Court, without finding any illegal action with Russia, it still thought that it is responsible for any actions of the Transnistria government. For such thing, the international law specifies very solid criteria of the extraterritorial responsibility. Such extraterritorial responsibility only comes into force when there is an illegal action. For example, in accordance with the draft article on the responsibility of states for international illegal actions, each international illegal action of a state leads to an international responsibility, international liability of such a state. international illegal actions can only take place when there is a behavior, either action or inaction, is attributed to the state in accordance with the international law and constitutes a violation of the international rule of such state. A violation of an international liability only comes into force when the state is not doing something that is required from it, irrespective of the character of its action. Recognition of such an act as being illegal is identified by the law. Also, in the context of Transnistria cases in the European Court against Russia, we can start thinking about using point 2, Article 10, of using insurgency forces. In accordance with that, insurgency forces or any other forces that is capable of creating an additional state or additional entity on the territory of the existing state is treated as an action of such state and has to be treated in the framework of international law. To our mind, international responsibility of such newly established entity can become a topic of a roundtable. In accordance with the comments of the Committee on International Law to this draft article, in order to qualify any behavior as an act of international law, this behavior must be the one that can be attributed to the state. And apart from that, any act cannot be considered to be an international law one if it does not violate the international liabilities of such a state. The common rule of attributing responsibility is as follows. The state can only be attributed behaviors of any entities or bodies that are acting under the order, the decree, or commission of the state, meaning the agents of the state. There comes a question, can we attribute the powers and the governments of the Transnistria region as somebody acting on the order and on the commission of their state or of Russia? Because in the European Court there are no such descriptions or no documents that would prove otherwise. For example, in the Katan case, there are no evidence that in the period at question the Russian militants were directly or through the Transnistria government were doing any actions that violate the international law. In such a way, due to this very specific treatment of effective control by the European Court, Russia is given responsibility for actions that it didn't take part in, and it didn't initiate in any way, and it didn't control them. With the absence of a common definition of effective control in the European Court of Human Rights, its treatment is too expensive, it's too general, and is on opposition with any other treatments of the same concept. For example, the international UN case. For example, in a well-known case, Nicaragua versus the States. We believe it is unacceptable to render such a discriminatory approach to Russia when only criteria of influencing of decisive influence are used. These are novellas, I think you know about them, about the decisive influence and close relations and how they differ from the concept of effective control, all by means of rendering economic, financial and military support. These criteria are unique in their nature and they're used selectively. In not any other single decision of the European courts dealing with extraterritorial jurisdictions they were not used. Such criteria are also unknown to any other international courts. We are concerned that the European Court of Human Rights is starting to reach out of its jurisdiction more and more often and takes on board questions that have to be dealt with by other bodies or have to be reviewed in a way of contract negotiations. And it starts dealing with questions that are outside its competence. For example, who are separatists, whom we can call occupants, the understanding of the separatist or occupational regime. And in this context, I think we need to provide a point of view of a former judge, Anatoly Kovler, who was also a representative of the Russian Federation at the European Court. It was his opinion about the Yevlashka against Russian Federation case. There was a situation when the human rights issue becomes the issue of policy. We also need to notice that the decision of attributing responsibility for the intermediary is not accepted by any other recognized courts apart from the European Court of Human Rights. I think with such a decision we are discrediting the very institute of intermediation and peaceful settlements. At the end of my talk, I would like to ask a question. Can the government really realize and implement the resolution of the European Court, such as the Katan case, and take on board all the decisions in there? To my mind, this answer is evident. This resolution is not realizable. Because otherwise, if we do accept that, it means that Russia was interfering with the actions of other states. This is the Yevlashka case, and when I was preparing to this speech, I understood that this genre of my presentation can be described as an old Russian genre, which is called lamenting or lament. And yesterday it was brought to my attention that another case was being brought to the European Court of Human Rights about the Transnistria, Moser and others versus Russia, or versus Moldova, sorry, and probably the court, when discussing this case, will come back to the questions I have just outlined in my presentation. Thank you very much for listening. Konstantin Dolgov, please. I will remind you once again that Konstantin is the ambassador at large, the Minister of Foreign Affairs of the Russian Federation, Commissioner for Human Rights, Democracy and the Rule of Law. Thank you very much. I have basically two advantages. You see, us, the diplomats, can always put any situation to their benefit. Well, I will be the last to speak. No, you're not the last to speak, because Konstantin will come after you. Oh, sorry, Sergei will come after you. So this wasn't an advantage then. And the second advantage that I wanted to share with you is that I'm not a lawyer. And not being a lawyer, but being a person who has to, for quarter of a century, deal with a number of questions in close cooperation with lawyers, both Russian and international, and having a great experience of working in the Russian mission to the UN in New York. I dealt with a number of issues of General Assembly, the Security Council, the OSCE, international cooperation. I had a number of things and ideas I would like to share with you. Some time ago, at the very beginning of my professional career, I had an interesting talk and conversation with a very well-known lawyer, international lawyer. Was a very wise person, a very experienced man. We were sitting at a dinner table and we were having a chit-chat, and for 2 hours he was telling me how important it is to strictly follow the principles and norms of the international law. I didn't know back then how many principles there were, 7 or 10, That was still too difficult to me. But the word itself, this principles and norms of international law, was basically the quintessence of what he has been talking to me. And being young at that time, I was trying to soak in his knowledge. I was even trying to take notes on a napkin. But then we stood up and he told me, you know, the law is like a sieve. And I remember that for the whole of my life. And today, what we see at the international arena, today, all the things that are happening, it's basically the same thing. The law is like a sieve. You know, there are all those different principles, like the principle of integrity, the principle of untouchability. For me, actually, these two things are almost indiscriminable. But I would even name another principle in here, the principle of self-identity. You know, in 40s and in the 40s and the 50s, a lot of blood was shed to protect this principle, and a lot of parties were taking part in this discussion, including the USSR, the States, some colonial countries, and there were a lot of different articles written about that, a lot of different and interesting books. But I would like to give you one simple example, the example of what we call double standards. Esteemed Mr. Minister, the Ministry of Justice, together with our Serbian colleagues, we work hand in glove about the Kosovo problem. I fully agree to what you said. And why I agree to that? Because I was dealing with this thing for many years in Moscow and in New York. I was attending each and every meeting of the Security Council when the Kosovo issue was raised. I didn't even go to Obsk. I was there at the Security Council, attending the meetings. And everything that we heard back then, from our foreign colleagues about the right of self-identity of the Kosovo people. The Kosovo people is actually yet another interesting term. We know what are the Soviet people, the new historical community, but what is the Kosovo people? Because after hundreds and thousands of Serbs, Gypsies and others were driven out, Romas were driven out of the country, just the Albanians remained. And the Albanians formed the Kosovo people. And even these Albanians are not Albanians, the true ones. If you talk to them, you will understand this very well. But nevertheless, back then we were said that self-identity is a sacred right, and you cannot even try to stop it. This right must definitely be implemented and realized. And we were quoted. People were quoting the UN Charter to argue with us. They would show it to us and say, see, this is what's written in the Charter. The USSR cannot combat that. Well, we said, it's all okay, but there are some smaller nuances, such as ethnical cleansings. There was no referendum, nobody was asking anyone. But they told us, these are minor things, these are nuances, don't even notice them. The most important is that you don't have to stand, as they say now, on the wrong side of the history. Well, several years have passed, and 2 million Crimean citizens have voted, have come to vote at a referendum, and the very same people who were talking about the sacred right of self-identity for the Kosovo people were very adamant and were very active in arguing with us that this is not the act of self-identity, this is the act of aggression of Russia against Ukraine. I remember what is an act of aggression of, for example, against Kuwait. This is aggression, or against Iraq, because there were planes, there were tanks. This is the kind of aggression we're used to, but in the Crimean case, we don't know what's happening. Those who are arguing against us are using the same terminology in a different way. There's a certain right in international law, protection of civil rights, or the liability of protection. So many words were pronounced and were uttered about this new concept of securing civil population. But until 2008, much more words were said after the well-known events in the southern Ossetia, this Georgian-Ossetian conflict. After that, this stream of words gradually turned into a small stream, a small brook. And the Western interest started diminishing and dwindling, and now nobody even remembers about that. If you try to raise this topic again, the responsibility for protecting the civil population, you have to really pay for this topic to be raised, because nobody wants to bring it up again. Because we understand what kind of answers will there be if we will bring it up. Unpunishable, impunity. How many wonderful words, or not so wonderful words, were said about that. There were so many battles in the UN and in other venues about the impunity that was done on the territory of former Yugoslavia. We will never let that be. We must prevent it from happening. But that brought the appearance of various commissions and so on and so forth. And again, we don't see the actual result. Where is the result? Have we combated and have we conquered the impunity on the territory of former Yugoslavia? No, definitely no. Not a single expert will say that this victory has been achieved, because there is no victory.
Maybe there has been a victory over Serbian impunity, not on Croatian or Bosniak. It was never achieved. I'm just calling things fair and square. I don't mind again Bosnia or others. I like them and respect them. They also had their criminals, didn't they? Military criminals, I mean. What do you do with impunity in Ukraine? We can have another white book published very soon, hopefully by the Ministry of Foreign Affairs. Some other white books published by NGOs. But we don't need actually white books. You just switch your Russian TV set on, and everything is clear. BBC would broadcast anything that you like, except what really happens in Lugansk or Slavyansk or Kramatorsk, not to mention Odessa or Mariupol, because that is not happening for them. What is happening for them is just an anti-terrorist operation. That's it. Let's recall then the attitude of our Western counterparts to an actual anti-terrorist operation in the North Caucasus. Self-obvious, isn't it? Will impunity prevail in Ukraine? We hope not. And hopefully not all details are clear even for ourselves, but of course it will not. We'll do all we can so that criminals will have been punished. But people will tell us instead, of course, not very good things were being done, but on the other hand, you know, that's democracy in movement in Ukraine. That's what it is. The people have opted for the European choice, and the people, part of the people, a small part but considerable part, is marching under the Nazi banners towards the United Europe. I have a simple question, ladies and gentlemen, here. What about the Nuremberg Tribunal? Did it exist or not? What about its decisions? I don't have the UN chart with me. I used to carry it on myself when back in New York City. Losing my habits, you know. But it reads plainly. But that surface of consideration doesn't exist. There are some people like the Pravi sector, the right sector, they are just marginals. Some marginals, 90% of the National Guard. The only more or less able to combat part of the Ukrainian military, people who can drive a tank. This is what we call double standards. This is what you can call an absolutely vicious use of international law for the political ends. To the political ends. I wouldn't talk about fragmentation, whether or not it exists. I'm not an expert. It may be the stratification or weakening Of fragmentation, all these words can be used, but the main trend is using the international law for the to the political ends. Can you do it? Can you do this or not? Our position of principle is Russia protects international law, that the principles and goals of the UN Chart should be followed. That's goes without saying. But being a quasi-expert, I would say all these have to do with politics, intergovernmental relations, and realpolitik is something that everybody understands. The realpolitik is back. That's clearly. Even we don't read articles about the end of the history and the victory of neoliberalism. Mr. Keegan, I met him personally, published a wonderful article one of those days. A fine article for him. Pax Americana. Ladies and gentlemen, we just need to handle it a little better to improve efficiency. Who's not with us, woe be to him. Clearly and exactly, no one recalls the UN Charter or international law. Clearly, they will be twisting other people's arms for their own sake. Can you do that? Maybe you can, but then why don't you become square and fair? Why don't we agree on an international level? I'm talking not as a representative of the Ministry of Foreign Affairs, just some observer of international relations. Why don't we sit down and agree that everyone will do the same? All of us and everyone will do the same wherever we are, in each other's weak spot or backyard, whatever. But then chaos will reign. Then people who are in favor of double standards would say, no, we didn't mean that. We can do it, Russia cannot. Why this concept of responsibility to protect is not recalled anymore, or some other, hardcore experts. Why? Because it was designed, it had been designed to fit specific political goals of several states, of just one state. Once the need was gone, once those principles started to be implemented by someone else, at once the concept was no use anymore, and they started to look for other concepts. What about the safety of person concept? The Japanese counterparts or colleagues, they have spent so much money on giving lunches and dinners internationally to promote the concept of the personal safety concept. Where it is now, I haven't heard about it since quite a while ago. Maybe my colleagues from the Ministry of Foreign Affairs still mention that, but it's not much about that. Why? Because it is not profitable to mention it anymore. Look at the East Ukrainians' personal safety. What about that? Hundreds of thousands of people who do not want to share the same state with the Nazis. Or when residential districts are being bombed day and night, calling that an anti-terrorist operation, do they have personal security? If Mr. Poroshenko, if Kiev is at war with several hundreds of extremists, as we were told, or terrorists, then why does it take so long to fight them? Because they're fighting the people, not the terrorists, part of the people. So you need to sit down with them to negotiate and talk, especially as all basic agreements have been drafted on paper. The roadmap is there, but nothing has been done to implement it. Next to nothing. Now they're counting days. We're going to finish it in 5 days, in 7 days, in 2 weeks, this way or that way, or let there be truce, and everybody should leave the East Ukrainian parts. Where they would go, yesterday on the Council of Federation, I talked to Mr. Borodai and Mr. Tsaryov, well-known leaders of the southeastern Ukraine. They said, we're not going to live anywhere. That's the place where we live, and we want to live there from now on. And our kids and our friends and colleagues, but we want to live there. But we want to live there in a civilized way while being able to speak in the Russian language, which is quite a... What about international law? It's only us who recalls that. We're being told aggression, infringements. Okay, why don't you go and show some evidence of that? Evidence of aggression, because lawyers, you gentlemen, ladies and gentlemen, you are fond of facts. We do too. You'd never go to court without having evidence on your hand. You would be defeated there. Where is the evidence? They say you are in general infringement, but you cannot do it generally against the international law. Only specific infringements can be counted in, and we will try to do our best so that the people to be punished should be punished. There are two ways out: to start negotiations and on the international level to agree on how to improve the international law. I don't know what kind of improvement should be made. I'm not an expert myself, but improvement that would take into account the most recent trends in a mutually acceptable way. Because what is international law? It's a safety net. It's a regulatory net allowing to avoid serious tension, whatever the reason for that. Either we come to terms, because international law has always been developing. Why do we seem to be stopping? But let that be a collective effort. Or let's agree that everybody will violating international law, however and wherever and whenever he pleases, which is a bad way. Or thirdly, why don't we try to minimize, like we discussed it with you, can we get rid of double standards? Well, it is difficult to get totally rid of double standards, but let's try to minimize double standards at the very least. And the very last example, I know I'm not the last speaker during the session and I have to wind up. One of those days there were some talks with a respectable European delegation, my counterparts in human rights area, and that lady, well, I put on the table the draft resolution of the Security Council denouncing the attacks on the Russian embassy in Kiev that was blocked by the Western Security Council members. I asked her, please tell me, look at this paper. What do you not like about it? It's all right, she says. We can edit a phrase, a word, add in something, but you cannot but accept this resolution. Was it an attack? Yes, it was. Was it an embassy? Yes, it was. And then the consulate in Odessa on the next day. Is it prohibited by international law? Yes, it is. Vienna Convention, it's there. Precedents, oh yeah, for Americans and the English. Precedents are there, dozens of such. Why do you not accept it then? I can only guess, although things seem to be very clear. She responds by saying, well, politically we have some disagreement about the situation in Ukraine. Come on, ladies and gentlemen. When in a situation like this, political discord should be shelved away. This is about international law, purely and functionally. Vienna Convention, is it abolished? Are we going to forget about that? Or we put it on uphold? Or do we uphold it? There was no answer, despite very good atmosphere during the talks. Why? Because everything was clear. That is the true dilemma that is faced by the current international law as seen from a usual diplomat like myself. Lawyers will correct me if I'm wrong, because I must have made some mistakes in my speech, but this is a trend that we have to face, and something needs to be done about it, and hopefully this discussion could touch upon this as well. Thank you. Thank you, Konstantin Konstantinovich. Sergei Vladimirovich Usoskin is taking the floor, head of the research programs at the International and Comparative Studies Center in Moscow. Thank you. The previous roundtable discussion this morning that I attended a good conclusion was made that international law operated differently depending on whether or not it was related to politics or it was a more political or more legal or technical one. I'll try to discuss the application of technical and legal aspects of international law and how within that framework the principle pacta sunt servanda should operate. It was mentioned this morning. And I will consider that as exemplified by international trade agreements and investment protection agreements in the context of a problem that goes like this. Well, pacta sunt servanda is a principle which should be self-obvious, but like in many other principles, it has some nuances of the gray, shades of gray. Contracts should be fulfilled, and one of the shades there is the need to protect by the state of certain general public interests of its own citizens, example being the legislations adopted by some nations against smoking of tobacco to protect health of citizens, countries like Australia or Uruguay, and they were subject of disputes under the WTO and some investment protection agreements because certainly they put some limitations on the freedom of trade and some limitations on the disposal of investors' rights. During those disputes, it appeared that these regimes are very different in terms of how to protect such public interests in the context of the state protecting its vital interests. On the one hand, the WTO system has some flexibility ribs in the form of general exceptions, allowing the nations to step back from its commitments in case some interests stipulated there should be protected. And the agreements on protection of foreign investments, including the one concluded by Russia, does not explicitly state that, which is an illustration of a different principle of international law, equality of the states. And the fact is that these regimes, both to regulate economic relations, had very different origins. The trade regime was for the relations between developed and developing countries, while the regime on the protection of international investments had been originally aiming at the relations between the developed and developing nations, so that guarantees to be provided to international investors would only be given by developing emerging economies, so that the developed economies never thought about what you would do if the agreement you has no exemptions or limitations, if some limitations are imposed or some product is prohibited, and what they would do if such a decision is made by the national government, thus effectively preventing them to implement their public functions as sovereign states, while potentially infringing on the interests of foreign investors. This is a pending issue which is being addressed differently. One of the methods to address that is going to international courts, which even in the absence of explicit provisions allowing to step back from commitments if you need to protect the public good, they would derive those from some general principles to be taken from the respective agreements or international law. If originally the agreements contain a limitation not grounded on anything for exacting of property or similar measures, or equivalent measures to exactment of property, while the arbitration practice says that the nations are entitled to limit such activity if that is required for the state to function properly as a sovereign. for the while protecting the public good. So this is the necessary flexibility on top of the need to fulfill the agreements, and that happens because there are international courts to do this. There is another mechanism, obvious mechanism, that is the change by the states of their own programs to conclude international agreements. Early on, we would see very simple agreements just to protect investors' rights. The new agreements that are concluded by the United States or Australia or Korea or Colombia or some other countries, they finally have started to add some flexibility immediately into the body of the agreement, which facilitates dispute resolution afterwards, because they would not need to prove that that was some legal activism. They would refer to the provisions from the body of the agreement itself. By giving this discretion to the states, the new investment agreements should learn from the lessons that we can learn from the practice of application of the trade agreements, including the WTO agreements that allow the states this right. On the other hand, some states tend to abuse this right under the slogan of protecting the public good or international security. They would take measures whose effective end is discrimination while infringing on its own commitments. And the example of that would be provision Article 21 of GATT that provides the nations the right that when they need to protect substantial vital security measures, they are free to take measures that they see fit, and that could be the ground to which some countries refer to when introducing sanctions in violation of trade agreements. And I would like to make this conclusion from this experience. Even trade agreements state that wherever we provide some flexibility, there must be an umpire in place to check the limits to that flexibility so that the whole system is not broken. I think such an opportunity exists even within the WTO, and let's wait and see if it is realistic to expect that. But we need to admit the need to be flexible while we follow the Pacta Sunt Servanda, and the decisive role still belongs to international courts, so that we could have some unbiased control over these things. Thank you.
Thank you, Sergey. Esteemed guests, we still have some little time, but if you want to ask panelists questions, you're welcome. I will try to be unbiased, and I will try to involve everyone who wants. We will ask for the mic. Yes, please, give us the mic. Professor Yershov, Russian Academy of Justice. I have a question to all the panelists. This is a scientific conference, so I would like to come back to the academic part of our agenda. My first problem, which is of principal importance for me, a problem that I have studied a lot, it is the legal nature of principles of international law. Many authors write that those principles are an idea, and this concept, in my opinion, is quite arguable. So I would like to listen to the presenters if they have an opinion about that. I would like them to speak about the legal nature of the principles of international law, or whether that is politics, or whether that's double standards, or what is the nature of those principles. Our conference is called the Supremacy of Law, and many panelists used that term. And I have a question to which I failed to find an answer in the literature. But if you have an answer to that question, is the supremacy of law Well, the supremacy of law is supremacy of what over what. This is not politics. And if it's a legal term, if it's an academic term, I would like to hear the supremacy of law is the supremacy of what over what. Let's get distracted from court rulings, from politics, from practice. This is a scientific conference, and I would like to hear a scientific answer to that. Thank you, Tatiana. I thought you would be the best one. Probably I failed to express it quite clearly. I was trying to say it. We must always remember what is the source of law. It doesn't appear by its own. The international law, which is very clear-cut, which is very complex, which is the most legal of all laws. There is a trouble with it. Concepts, declarations, and that was mentioned today, that declaration is law, and other things are substituted for law. The problem with that international law is that it grows very slowly, is that it ripens very slowly. More than any other legal system, it is related to real life, not to policy. On the outside, it is related to politics, but it's the national law that is related to politics and the regime, while international law is related to natural laws, to human life. It has been developed like that. In a philosophical sense, it started as a religious concept, from religious, ethic, and aesthetic, and biological ideas. I started with that. Thomas of Aquino, and the president of Russia likes to cite him, clearly said that there are three laws, and all the other law follows from it. Everything else has been established and became part of law, became principles only in a very well-developed society. And so far, we do not need to introduce into international law what's not there. The efficiency of defense, etc. Those are institutions, those are not principles. There are very few principles. And the principles that were invented but were based on the Second World War tragedy, this non-use of force. It did not grow naturally. But this language in the UN Charter is a language, is an agreement that took account of politics. So what do we see as a result? We see permanent violations. Because the real international law provision must be substantiated by centuries-old practice. If it's a new one, there will be a lot of violations. So from the standpoint of philosophy, these are the basic ideas that derive from human life and that were embodied in law. And it doesn't matter how. Whether they are part of the UN Charter's super imperative provisions. The Vienna Convention clearly divides between usual norms and super imperative norms. I'm calling upon you not to substitute one for the other. The judges will still use those notions. It's not an agreement. I remember that these norms have been already used by Constantine and by And so it's not only pacta sum servanta against public order. In certain cases, public order precedes pacta sum servanta. So this is a judicial tool because all of them are equal. The self-determination is equal to integrity. There is no principle of non-violation of borders and boundaries. But in every situation, one or the other principle dominates, and the task for the lawyers is to use that to be capable of justifying, because the judge will only work well when he gets good evidence and justification. Of course, a bad judge wants this to be written in the agreement, but you need the principles, especially when nothing is written in the agreement. And the situation with Serbia, with the Crimea, with Ukraine, and I can say that the people guilty will be punished. The UN committee has already set up a commission to investigate the events in Odessa, and Nikola Bratsa is at the head of that commission. He will figure out. Nothing will be forgotten. It's the fact that the international law works slowly, and of course the situation will not be resolved tomorrow. But the problem of our country nowadays is that we have very few international level lawyers who can apply those principles. There's a lot of people who can apply that principle as politicians, but politics and law do overlap. They don't exclude one another, but those are different things. And the supremacy of law position is a position that was introduced thanks to my teacher, Professor Turkin. He wrote that book, The Supremacy of Law or Supremacy of Force. I don't know whether you read that. He argued very much with Americans back in the 70s who thought that in international relations there must be supremacy of force, and they continue to insist on that today. He wrote the book, The Supremacy of Law. He got a number of prizes for that, a huge number of prizes, and after that the term was generally accepted. It was accepted that in all public relationships, law must supersede the force. That's my answer to the question. Ideology takes a lot of time to become law. Don't mix up concepts and principles. Well, I believe Konstantin wanted to add something to that. Briefly, I think Niels Bohr said that the best scientific conference is practical experience. I fully agree. Science separated from life is not science. But as for the supremacy of law, by the way, the term that we borrowed, this is the priority of legal methods in providing personal, corporate, national and international interests over any other method, including force. So, in my opinion, this is the briefest formula. It stands different matter how it's all applied in practice. Well, I don't know whether I contradict myself and whether I will cause the anger of Tatiana. Grigory Tonkin, in his lecture, said that nothing is more practical than a good theory. Konstantin, that's to you. Exactly 1 month ago, President Obama spoke at West Point Academy. You know, the supremacy was given to military form. And of course, he said that in other situations we will use international law, so we must hope for the better, but be based on objective reality. And the objective reality is such that the law is deficient. The law is reactive. Yes, you need a tanker to get aground and to spoil the shoreline for the governments to work out a convention. You need Chernobyl to blow up, and then the governments will get together and develop a convention on compensation for nuclear damage. Maybe the time has not yet come, but we must be based on reality. I didn't say a lot about the use of force that I wanted to say. Yes, we must defend the principle of law, we must protect it, but the optimal tool for that protection would be force. But if we use that force outside our own country, we must provide very clear legal criteria for such use of force. We will be doing this then and then and then. Let the enemy tremble. But we must clearly know what we will be doing in which situation, and we may present that position in the UN Security Council if there are any claims against us. Bakhtiyar, yes. Thank you. Dmitry Nokhrin, Deputy Judge, Constitutional Court. My question will be rather to Konstantin and Bakhtiyar. Recently, we hear from a number of international experts that the Kosovars' law for self-determination was implemented after a long armed struggle, whereas the rights of the people of the Crimea for self-determination was not supported by this massacre. How much this principle of armed struggle, bloody struggle, is related to the right for self-determination? Excuse me for being cynical, but you provoked me. As for liters of blood spent, the Crimea may argue with Kosovo. No one measured that blood over the centuries. No one. There's been a lot of Russian bloodshed in Crimea. Not only Russian, but mainly Russian. So this criteria is absolutely inadmissible. The concept of the preventive activity, which were underpinning all the NATO operation, the preventive nature, it has never been preventive because there was bloodshed, and then during those operations there was even more bloodshed. And those operations were either in violation of the UN Security Council or in violation of the resolutions of the United Nations. They were interpreted in a very peculiar way. The objective is to provide the real preventive nature, and that is to solve via political and legal mentions, to resolve the potential conflict. And that's what happened in the Crimea. And the president and the government of Russia have been emphasizing that there was no bloodshed. And that is the best thing. And we are told that we will have to wait until blood is shed. But if you do that, strictly speaking, and coming back to the international law, why do we need the corresponding provisions of the UN Charter if the international community waits for the bloodshed? So I believe that the concept you propose is absolutely corrupt and vile. Luckily, it's not codified and hardly will be codified. But the historical parallels are sometimes very useful, because it seems to me that when you talk to your Western colleagues about the Crimea and Ukraine, you see that they haven't read all the books on that subject. While it would be very favorable for them to familiarize themselves. Bakhtiyar, would you comment? Well, the challenge is there. Also, the deputy judge of the Constitutional Court could pay attention to the disclaimer I made that I will not be speaking as the judge of the Chamber of Appeal of the International Tribunal. But what's added is a personal attitude. I've been in Yugoslavia during the conflict, and if I say that this minister of Serbia will say that I must retire after this, I have to agree with Mr. Dolgov. If I were in charge, probably the rhythm and the tempo would have been different. The rhythm and the tempo. Faster or slower? Thank you. Yes, please. The mic is with someone who asked the question. Can you pass on the mic? Esteemed panelists, I must have to warn you. Careful, we deal with hungry people. We're dealing with hungry people, so try to be brief. Garik Oganesyan, Armenia, managing partner of the company Ivanyan Partners. I have a question to Konstantin and Bakhtiar. Finally, the two principles of international law, the right for self-determination and the territorial integrity. Can they coexist in real life, or are they mutually exclusive?
There's no opposition in here. A lot has already been said by Tatiana and other panelists in this regard. We talked about this lack of red lines, and I think it's all relevant and it's all true. But there are specific documents that demonstrate exactly this. For example, in the UN documentation, it says that one cannot become or can come into odds with the other. The government, the state, that can have the right for its territorial integrity, but at the same time it must ensure that all the rights of, say, ethnic minorities and other minorities are protected. And that's what is not the case in a whole number of situations. I won't now call any specific examples, but everybody knows what I'm talking about. Everybody knows who is not protecting which rights. If the rights of minorities were protected, and I'm not talking about the Ukraine right now, and there are other examples, if the rights of the minorities were not protected, then the international community would not be faced with a question on ensuring territorial integrity of the states that we are discussing right now. There's no problem with integrity. It didn't all start from the integrity. There is an internal conflict from where it all started, so we're talking about the internal conflict. Thank you. Bakhtiar, the question is yours. When Tatiana talked about super imperative, well, use this term super imperative, and I would also use another term in here, root principles or basic principles of the international law. I think her position was very specifically and very clearly stated. There's no hierarchy between those principles, they're all equal. But in a particular situation, we refer to a particular principle. This is one. Second thing, self-identity as in its extreme form provides for a possibility of a state to separate. And in case of need, it can separate using the armed forces. As for the territorial integrity, realpolitik, am I pronouncing this right, Konstantin? Realpolitik, am I pronouncing it right? Realpolitik really shows to us that the potential of new governments and new states from forming is not yet exhausted. Thank you very much, Bakhtiar. What I would like to suggest to you, let's take one more question and let's call it a day then, because it is really glad to be here with you, and it would be nice if I stayed here for 2 more hours, but people are getting tired and people might already start leaving already, and for us not to witness this situation and for us to avoid people from leaving, let us wrap it all up after one question. Thank you. I will basically repeat a question that has already been asked about the principles, but I will try to formulate it more specifically and more precisely. I won't be wrong if I say that in this modern paradigm, neo-normativism, there's one particular prevailing point of view, which states that principles are different from norms because principles are paradoxical in their nature. They don't require legal form or legal fixed form, so the judge doesn't have to prove their existence. They are free to use them, and this principle can block the use of any formally inscribed or prescribed norm. So I would like to listen to your opinion, please, Tatiana, about this thing. Yes, and this is exactly what I was talking about. It is in the nature of international law that such principles are used as super-imperative ones. Local norms are going away from it. European norms have gone from it back in the past, but they are coming back to it. And there are some regimes that do not recognize these principles. But as for the international law, there was no regime whatsoever that would encompass it. It is clear that such natural principles, the backbone of the international law, were agreed and approved through the Vienna Convention. There's only one question outstanding. How does it state in the Vienna Convention? It states that these principles are recognized by all or almost all the states of the world. So that's why you have to select not everything, but you have to choose only some things that are commonly agreed on. So, for example, this is the principle that exists for so many years. It came from this and that. It is used by this and that. It is used in a particular situation. It can have this kind of application or that kind of application. Well, these things are extremely important for a judge, because it's always too easy to add on to that something else, to adjust and attach something that is coming from modernity to it. But then no decisions will be followed, no rulings will be implemented, and people will say no to that. So you don't have to adjust this principle to the reality. You have to use them as they are. Well, whether the book will say this or whether it will not, or whether the government will say it or whether it will not say it, it doesn't really matter, because these principles already exist, and that's why the humanity exists. If you take these principles away, there will be no humans. That's why I started from these 3 principles: the right for life, happiness, and so on, because there are always people who want to violate these freedoms. And these principles are very often subject to violation. They're constantly being violated. Even in the internal law, lots and lots of things are being violated. And it is up to the lawyer, it's the art of the lawyer, to prove that it has to be otherwise. Today I've been listening to our distinguished Matushkin. Thanks a lot to Strasbourg, who said 3 times in a row that Transnistria region is ours. And instead of fighting against it, they said 3 times that we have an effective occupation and we're having effective actions in there. So we have to collect those decisions and to hold them and hold on to them for the future. We can't really say that Strasbourg is a bad thing. They actually helped us in saying that if you paid, it's yours. And this is one of the oldest principles of international law. The party that have effectively occupied and effectively pays for the region can really hope to claim the region for itself. Well, it's a joke on my side, but it actually explains very well what are those principles and how to use them in the right way. So I think Professor Yezhov has brought up a very interesting topic. We are doing not just blah blah in here, or we're not just we're doing science in here, and this science will help to ensure that international law will be recognized and will definitely be supported. Thank you very much, Tatiana. In wrapping up, I'd like to say thank you to the audience. Thanks a lot for being with us. Thanks a lot for giving a lot of attention to us. You were really listening. I could see it in your eyes. And thanks a lot to the panelists.